Okay, so now I want to talk to you about the settlement phase of the litigation. And so let's just fast forward to, we've done everything else we've talked about, and now we're at the settlement phase. That means that your lawyer, Mr. Schwartz, has been talking with the lawyers for Wyeth and Pfizer, and they've talked about numbers, and they do it in a group, so to speak. They refer to this as inventory. They settle inventories with the lawyers, and that is in no way meant to offend anyone or to lessen the seriousness of your case. It's just that at this point of the case, that is how they deal with settlements, and it's just an easier way because it really is at this point about the numbers. And so they refer to the inventory, and the inventory is, 1,600 cases or 300 cases or whatever. So at this point, we've got roughly 1,200 cases, and they're referring to that as our inventory. So they start talking about the inventory, so much per case, and they have reached a number. That means that it's not per person. They haven't individually discussed each person's case and values individually. That means they've discussed a number of an average per case. So they've agreed on a total settlement number for all the cases that we have, all of our inventory. So the next part of that would be that they've signed an agreement, that they've got an agreement to settle based on that number. We then have to hire an expert who will then come up with a grid or the criteria for settlement values. It can be a point system. There's various ways to do that. But bottom line is that expert is a neutral person that determines these are the criteria that we're going to look at. In each case, we will pull that criteria from each case, and you get so many points for each thing, and so the number of points then will have a point value based on the total number of the dollars settled for the group. At that point, each person, once we know how much the points are worth, and all that's calculated, again, way above my pay grade in the sense of math, because that's not my forte or my subject, but coming up with how many points for the value, and the value that then would equal the total settlement amount. So each person ends up with a number of points, and you multiply that times the point value, and that gives us each person's gross settlement award. The gross settlement award is, nothing's taken out of that yet. That's the gross number per person. And so everybody's will be different, okay, based on different criteria. And that criteria is anything from age at diagnosis to severity to your treatment, whether you've had double mastectomy, single mastectomy, whether you've just had radiation and no mastectomy. There are lots of different factors that are factored in. And when we get that grid ready, you will see that grid, and you'll get an opportunity to look at it and make sure that what we've given you credit for, so to speak, is correct and you agree with it. So then we've moved on and we've gotten everybody's gross settlement number. We will let you know then what your gross settlement number is. At that point, we won't know yet for sure what your net amount is, meaning how much will you get in the check written to you. Because there are expenses that we have to gather and calculate. There are liens and things, attorney's fees, referral fees. Again, I'll remind you that your contract you signed at the beginning of this litigation, anywhere from 3 to 7 years ago, states that you pay us 1%. It's a 40% fee, and if we have 10 lawyers on it, the fee doesn't change. It's still that 40% divided however all those lawyers have agreed to divide that fee up. So that part won't change. But there are expenses involved, and we have individual expenses. So ordering medical records for each person, we only calculate and assess to you what we had to pay for your records. But there are things we have to do that affects everybody, or is it for the benefit of everybody in the litigation. And so those things will be divided equally, those charges, and you'll get a portion assessed to you. Those are what we call master case expenses, because everybody benefited from that work. And those can be things from Mr. Schwartz's travel to attend the hearings, to anything that, again, that was benefited the whole group. There are also MDL fees that go, they're usually called common benefit fees, and expenses that go to the lawyers who had to try the case that helped us get to the point where we could settle this. So that's usually a percentage assessment of the gross settlement amount. The biggest issue is the Medicare and Medicaid liens. Those liens are what we call super liens. that means that the government requires us to withhold that amount from your settlement so that they get their money back. And what that really means is the government says, okay, if you have a recovery from a third party who caused your problems, your injuries, your damages, you collect money from them for that, then out of that money, anything we paid relating to why you got that money, we want our money back. So, more specifically is, they've paid for your hormone therapy drugs, they've paid for your doctor visits for your Medicare, for your breast cancer and your treatment, they've paid for your surgeries, they've paid for all of that. So they have an amount they've paid out related directly to the hormone therapy usage and your injury sustained from the hormone therapy usage. So what they want to do is they'll send us an assessment, we make the claim, and fortunately we have a group that the judge appoints, the Garrettson Resolution Group. This is what they do all day, every day. They've been doing it for probably 20 years or longer. So they're really good at this. They contact Medicare, Medicaid, they make the claims, and they start reviewing and assessing the itemized charges for each person to make sure they are right coded, that they are coded relating to the hormone usage and the your diagnosis and treatment of the breast cancer. Because that's all we're required to hold out from this settlement is what's related to that only. For example, and some of you might ask, if you'd been on Medicare or Medicaid and you'd been in a nursing home and then this happened, they can't make you pay back for all the nursing home care. They can only make you pay back what's related to the hormone therapy and the breast cancer diagnosis, okay? And it's not dollar for dollar. So let's say because this stuff is not cheap, and cancer care is not cheap, that let's say they've spent $100,000 on your care and treatment. You don't have to pay back $100,000. It's not a dollar for dollar deal. They let us negotiate that, and we have reductions in place, and all that's negotiated by the Garrettson firm, so it's a lesser amount. But again, we don't have a choice. We have to take care of those liens. That money will be withheld typically before they even send it to us, but in some cases they do send it to us and we have to get it to Garrettson to send into Medicare and Medicaid. There are also sometimes private liens, subrogation liens. The private subrogation liens we're not required to take care of. However, the Garrettson firm will do those for you as well if you are concerned about it, because if you don't take care of it and they can come back to you for a certain period of time and look for you to pay that back. And again, it works the same way. It's not a dollar for dollar. It can be negotiated. And if you want to pay that fee and have them resolve that for you, that's your choice. Again, that one's not mandatory. So we will certainly provide you information about whether you want to do that or not and take care of that. So the bottom line is, once we get all the numbers together, and we will give you a draft of what we feel like is all the expenses showing that's going to be deducted from your money, and it will show just exactly what we expect you to get in your pocket. Our firm's typical policy on it is that we don't take more than what you take. In other words, if our fees end up being more than what you would net, we make a reduction, and we make sure that you don't net any less than what we take as a fee. Now, sometimes with the Medicare liens and a few other things, it can work out to be real close. But we try to make sure that we are as fair about it as we can, and that we don't get any more money than you do, because we know this money is important to you. When we get to that point and you have any questions, you'll get an itemized list of all the expenses. You'll be able to review everything. It is all your money. Every bit of the settlement is your money. So that means that you have a right to, and we give to you, every penny deducted and why it's deducted. And you can question anything you'd like. We will be able to explain it all and hopefully explain it to your satisfaction. And if you have any questions during any of that time, we're going to all be available.
Again, this is a very lengthy process. My policy is that I'm always available to talk to a client. All you have to do is call. I have a number of great people that are working with me, and you can talk with them. But anytime you want to talk with your lawyer, you just call me. I'll explain your case to you. We'll discuss the strong points and the weak points about your case. And at any time, if you want an update, please give us a call.